Hello friends, very warm welcome to my business laws channel. Today friends, I am going to take up new chapter which is chapter number 4. Till now I have covered all three chapters. First was introductory chapter, nature of contract, meaning essentials of contract and kinds of contract. Second chapter was offer and acceptance. And third chapter was consideration. And the fourth is competency of the parties to contract. You know, friends, one of the essentials of valid contract as per section 10 is that parties must be competent to contract. Now the question arises, what is the meaning of the term competency of the contract? Who all are competent to contract? Competency of the parties to contract or capacity of the parties to contract has been defined under section 11 of the Act. Every person is competent to contract who is of the age of majority according to the law to which he is subject, is of sound mind and is not disqualified from any law to which he is subject. Thus, friends, capacity of the parties to contract has been defined in relation to age, soundness of mind, and legal qualifications. So, in other words, we can say, as per section 11, the following are incompetent to contract: minor person, every person of unsound mind, and every person who has been declared as disqualified from any law to which he is subject. Now, who is minor person? Any person as per section 3 of Indian Majority Act 1875, a person who is a minor. Minor is a person who has not completed 18 years of age. Accordingly, every person who has completed 18 years of age is a major person. The rule governing minors agreements are based on two fundamental rules. The first rule is that the law protects minors agreements, minors against their own experience and against the improper designs of those more experienced. In the eyes of law, friends, minor is immature person. He does not understand what is good for him and what is bad for him. That is why, all agreements which are entered into the minor are void agreements. The second rule is that in pursuing the above object, the law should not cause unnecessary hardships to the person who deals with the minor. We all know, friends, that minor is immature person. Lot of protection has been given to the minor, but at the same time, minor is not allowed to cheat men. Minor is not allowed to take the advantage of his own position, minority. So now, friends, I will take up the main heading, law relating to minors agreements. This heading is very, very important from examination point of view. Very often the question is asked in the examination, explain the law relating to minors agreements. Friends, I'll discuss 15 to 16 points and all the points I will take up one by one. The very first point is an agreement with the minor is void ab initio and inoperative. So there is a very important landmark case law regarding this, which is Mohiri Bibi versus Dharmodas Ghosh. I would like to explain the facts of this case. Minor had borrowed rupees 8,000 from a moneylender and executed a mortgage bond of rupees 20,000 in his favor. Subsequently, the minor sued for setting aside the mortgage on the plea of his minority when the mortgage was executed. It was decided in the court that mortgage was void ab initio. Even the money actually lent could not be recovered. So friends, when we talk about movable property, we use the term pledge. But when we talk about mortgage, immovable property, so then we always use the term mortgage. So friends, here, out of 20,000 rupees, only 8,000 was received by the minor. Now later on, minor wanted to set aside the contract on the basis of minority, and it was held in the court of law that minor was not to return even this 8,000 rupees to the moneylender. and moneylender could not file a suit against him. Even if he filed, he was not successful because all the agreements which are made with the minor are void ab initio. Void ab initio means they are void from the very beginning. They are void since their inception. He is supposed to be incapable of making the judgment what is good for him and what is bad for him. His mental faculties are not mature, and therefore the lot of protection is given to him by the law. The second law is the doctrine of restitution is not applicable in case of minor. So friends, what is the meaning of the term restitution? Restitution means, friends, if any person has obtained property or goods or any benefit from other person, then in that case he must restore it to that person from whom he has obtained. This is known as the principle of restitution as per section 64 and section 65. So the principle of restitution is applicable in case of valid contract, voidable contract, void contract, and agreements discovered to be void, but not in the case of agreements void ab initio. Friends, all these concepts, valid contract, voidable contract, void contract, and agreement discovered to be void, all these concepts I have explained in the very first chapter under the heading kinds of contract. If you have any doubt, then you can always write in the comment section. In all these cases, the court in the past have refused to allow restitution because of void agreements entered into by the minor. So these are all cases: Moiri Bibi versus Dharmodas Ghosh, then Khan Gul versus Lakha Singh, Shyamlal versus Rampyari, Kanta Prasad versus Shio Gopal Lal. So Moiri Bibi versus Dharmodas Ghosh I have just discussed. You all know even 8,000 rupees which was received by the minor was not to return this benefit to the moneylender. And now the doctrine of restitution is applicable against a minor where he is a plaintiff as per section 33 of the Specific Relief Act 1963. Now this section provides if a minor obtains property or goods by misrepresenting his age, he can be directed by the court to restore it, but not so long as the same is traceable in his possession. This is known as Equitable Doctrine of Restitution. Where the minor has sold the goods or converted them, he cannot be made to repay pay the value of goods because this amounts to enforcing a void agreement. So if minor has misrepresented his age, say he is at the age of 17 years, but he misrepresented his age to be of 21 years and he has bought motorbike. Okay, and then at the time of payment he says, no, I was minor person. A motorbike is in his possession. And the other party goes to the court and wants to file a suit against the minor. And minor cannot be sued by others, but minor can sue others, but minor cannot be sued by others. Then the other party can knock the door of the court. And the court, if the court thinks it is proper, court will give the directions to the minor to restore this motorbike to the seller. So friends, here, if minor is not allowed to cheat men. So we all say that principle of restitution is not applicable in case of minor, but under some exceptional case, if the court gives the directions to the minor, then minor will have to hand over that particular item or goods to the other person. But he can hand over only if the item is in his possession. If he has passed on to other person or the item has been destroyed or it got destroyed, then this principle will not apply. Now moving ahead, friends, now the next point is all beneficial agreements are valid contracts. All agreements which are made with the minor for his benefits are valid contracts. There is nothing in the law which debars a minor to become a beneficiary or promisee. Such contracts can be enforced at his option but not at the option of other party. Law does not regard a minor as incapable of accepting a benefit. Sorry friends, minor can always accept the benefit. Now, a contract of apprenticeship is valid and it is binding upon the minor, because such contract is protected by the Apprenticeship Act 1961, provided the following two conditions are satisfied. That is, minor can enter into the contract of apprenticeship as per Apprenticeship Act 1961, provided two conditions are satisfied. Out of this, the first condition is minor must not be less than 14 years of age, and the contract must be entered into on behalf of the minor by his guardian. So he must not be less than 14 years of age. And second is that this main motive should be that why he is going to enter into the contract of apprenticeship. It should be to make him able to learn a craft and trade and to seek him a gainful employment in future. So friends, that he's going to learn a craft and trade so that when he becomes of full age, then he should be able to earn his livelihood. Now, coming to the fourth point, which is no ratification on attaining the age of majority. So ratification is subsequent adoption of the act, of some previous act or agreement. Ratification relates back to the date of contract. For a valid ratification, the person must be competent to contract, both at the time of formation of contract as well as at the time of ratification. So friends, the rule of ratification is not valid in case of minor. An agreement which is made with a minor, it is void, it cannot be ratified. No specific performance. No specific performance means carrying out the actual obligation of the contract. Now here friends, if minor has committed default, then in that case the other person cannot go to the court and can bring specific performance order against the minor. So specific performance is one of the remedies which is available to the injured party in case of breach of contract. But there are some exceptional cases where, however, contract entered into or on behalf of the minor by his guardian or manager of his estate can be specifically enforced in the following two cases, where the contract is such that the guardian or manager has the authority to act and where the contract is for the benefit of the minor. Now, point number 6 is, friends, a minor can always plead minority. Now, the rule of estoppel does not apply to a minor. Estoppel is whatever a person says, he is bound by his words. But if minor says I am major, it will not make him a major. He will still remain minor. So there is a very important case law which is Leslie versus Shield. In this case, minor by fraudulent representing himself to be of full age, induced L to lend him 400 pounds. He refused to repay it and L sued him, held the contract was void and S was not liable to pay the amount. The court observed in this case, whenever the infant is still in possession of any property in species which he has obtained by his fraud, he will be made to restore it to the former owner and he cannot be made to repay money which he has spent. Friends, already have discussed this point that principle of restitution is not applicable. If the minor has tried to cheat other person and he has bought any item, then court can always give directions to the minor to return that item to the other person. Point number 7 is minor's liability for necessaries. This is a very important point from examination point of view. Section 68 of the Indian Contract Act is applicable where necessities are supplied to a minor and states if a person is incapable of entering into a contract and anyone he is legally bound to support is supplied by another person with necessaries suited to his condition in life, the person who has furnished such supplies is entitled to be reimbursed from the property of such incapable person. So friends, the last line is very, very important. Remember, he must be reimbursed from the property of such incapable person. So the term necessities has not been defined under the ICA 1872, but court has given rulings from time to time to determine the meaning and scope of this term. So the following have been held by the courts to be necessaries of life. There's a long list which is given: food, clothing, shelter, funeral expenses of deceased family members, expenses incurred for the marriage of female members in the family, expenses incurred for the education and training of minor, education incurred in connection with the performance of Diwali Puja, library for an officer's servant, horse when minor doctor ordered riding exercise, goods supplied to minor's life for a sport, rings purchased as gifts to the minor's fiancé, a racing bicycle. So all these, friends, are the items which have been included under the term necessities. Here the claim can be made against the minor's property being necessaries. This is the example before you where M, a minor, fractures his leg in a cricket match and his friend takes him to the private doctor and bears all the expenses of getting his leg plastered. So here, whatever expenses he has incurred, he must be reimbursed from the property of the minor. On the other hand, the following have been held not to be necessaries: goods supplied for the purpose of trading, a silver gift goblet, cigars and tobacco, refreshment to the undergraduate for entertaining, materials used in the construction of a house. So these will not amount to necessaries. What is a necessary article? It must be determined with reference to the status and circumstances of the particular minor. So we cannot say item is necessary for one, will be necessary for all. So it always depends upon the status or circumstances of the minor person. There is a very important case law, friends, which is Nash versus Inman. M, a minor, purchased 13 fancy waistcoats from N while he was already having sufficient garments to wear. Held these 13 coats were not necessaries and N could not recover the price thereof from the minor for any of them. So friends, here if minor is having too much variety of particular item, then in that case, and he buys more one, then in that case, this will not be considered as necessities. Now the question arises, what is the liability of the minor in case of necessaries? Minor will not be held liable, but if other person has incurred certain expenses in order to provide necessaries to him, then he will always be reimbursed from the property of such incapable person, but he shall not be personally liable. Now point number 8 is minor's liability in tort. The meaning of the word tort is civil wrong. If a minor in the course of doing what he is entitled to do under the contract is found guilty of negligence, he cannot be made liable for a civil wrong if he is not liable on the contract. Friends, there are two important case law regarding this. First one is Jennings versus Rundall. A minor hired a horse for riding purposes. Now, due to overriding, the horse was injured. It was held in the court of law that minor was not liable. If minor is not liable on the contract, then due to his negligence, if certain loss is suffered, then he will not be liable. And the second case is Bernard versus Haggis. M, a minor, hired a horse for his riding purposes. He was given the instructions not to jump the horse, but he gave the horse to one of his friends who overjumped the horse and the horse died. Here in this case, the minor was held liable. Now the question arises, why was minor held liable? He was held liable because he made the unauthorized use of the horse. Now, point number 9 is, friends, minor as partner. Now, can minor be admitted to share the benefits of the partnership firm? The answer for this is yes. Section 30 of the Partnership Act 1932 provides that minor can be admitted to share the benefits of the partnership firm if the other existing partners agree. But his liability will not be unlimited. It will be limited up to the amount of profits or share of profits which has been given to him by the other partners. Minor as an agent. Minor can always be appointed as an agent. But if he does something wrong, then he cannot be sued by his principal. But there is nothing in law which debars minor from being an agent. Principal must be competent to contract, but minor may be competent to contract or may not be, but contract of agency will be valid. Minor and insolvency. Minor cannot be declared as insolvent. Even he is not liable for the necessities which are supplied to him or his dependents under section 68. Point number 12 is contracts entered into by minor and adult jointly. Any contract, friends, it has been entered into by the minor and adult jointly, then in that case and the liability is not discharged, then the other person will file a suit against the adult, as minor cannot be sued by others. There's a very important case law regarding this, which is Jamna Bai versus Vasanta Rao. So point number 13 is surety for a minor. Surety can stand as anybody can stand as a surety for minor. But if the minor does not make the payment, then in that case, surety has no right to sue the minor person. Because minor can sue others, minor cannot be sued by others. So surety, anybody standing as a surety for the minor has to run risk. And if minor turns out to be the defaulter, then surety will not have the right to sue the minor, but surety will suffer loss in that case. But surety can always stand as a guarantor for minor person. Position of minor's parents. The parents of the minor, they are not held liable for the acts of the minor. If minor does something wrong, if minor is acting as an agent of the parents, then his parents will be held liable because all the acts of the agent are the acts of the principal. Minor shareholder. A minor being incompetent to contract. He cannot be shareholder of the company. A company can always refuse to register transfer or transmission of shares in favor of minor unless the shares are fully paid up. So if shares are not fully paid up and transfer is a minor person, then board of directors can always refuse the transferor, for transfer of shares. So minor can always be the shareholder. His name can be entered under his guardianship, under his guardian in the register which is maintained by the company. Now friends, till now I have covered all 15 points pertaining to the law relating to minor under ICA 1872. So is minority a disqualification? The answer for this is it is not, because it always acts as a shield which provides lot of protection to the minor. Minor is the privileged person. He has been provided lot of privileges under the law. So all the agreements which are entered into with the minor, we can put them under 3 heads. First one is valid contract. Second is valid contract, where necessaries are supplied to the minor. Voidable contract, where minor is the payee or the endorsee, then the contract becomes voidable at his option. And the third is void ab initio. So all the agreements which are other than the valid and voidable, they are known as void ab initio. They are void from the very beginning. They are void since their inception. Friends, it is all about the laws relating to minors agreements. under chapter number 4. I hope you will like the content. And if you have any query, any problem, any point is not clear to you, you can always write in the comment section. Do like my videos, do subscribe to my channel, press on the bell icon so that you can get notifications of my subsequent videos. Goodbye, friends. Stay blessed always.